Good morning, everyone. I want to welcome you on this rainy Tuesday. I'm Alicia Bowman. I'm the Associate Executive Director of the Connecticut Association of Schools and the Director for the Center of Leadership and Innovation. Thank you for taking the time out of your very busy day to attend this eagerly awaited Legal Updates webinar. It's an annual favorite of educators from around the state of Connecticut. Today's webinar is entitled 2022 Education Legislative Update, and it's presented by our distinguished guest, Dori Antonetti from the School Law Practice Group. Before I begin, I just want to thank our corporate sponsors, Horace Mann and the Connecticut Higher Education Trust, or CHET, whose ongoing support helps to bring high-quality professional development to school leaders in Connecticut. This year's CHET Dream Big competition is now happening, and it's through October 21st. There are some exciting changes to this year's program, and Connecticut residents in grades K through 12 are eligible to enter. The Dream Big prizes are even bigger this year, and students have a chance to win monetary contribution for college savings. So please check out chetdreambig.com for more information. I also just want to go over the logistics of how we'll proceed with the webinar during our presentation. All of you in the audience are muted. You can share any questions that you have using the Q&A feature during the live presentation. Dori will also present scenarios and provide some time for reflection and then walk you through the key points. We are recording the webinar, and we will make that recording available to you in the next few days. So now let me introduce my colleague and professional friend, attorney Dori Antonetti, who's a member of the School Law Practice Group. Dori graduated from Georgetown University and earned her law degree from the Catholic University of America. In her day-to-day work, Dori draws on her unique experience as a former educator for Teach for America. This experience, coupled with her time as a hearing review officer in the New York City Office of Labor Relations and a kindergarten teacher in New York, allows Dori to analyze issues from a practical perspective, which brings significant advantages to her clients. In addition, Dori teaches a school law course at the University of Connecticut's NEAC School of Education. Dori and the entire School Law Practice Group are good friends to CAS, and we are so thankful she can be here to share her expertise today. So without further ado, I would like to introduce Dori.
Good morning, everyone. And Alicia, thank you for that warm welcome and introduction. I really appreciate it. I am a school lawyer with Shipman Goodwin. I've been here for about 3 years, including the crazy 2 COVID-19 pandemic years. And as Alicia said, I have long ties to education. My first job post-college was as a bilingual kindergarten teacher in Spanish Harlem. So education's kind of at my core. My sister's a teacher, my mom was a teacher and a principal. I have lots of family members in education. So before beginning, I just want to say to all of you as educators out there, thank you for the really important work you do for our school districts and for our children across the state. Today, we're going to be going over the 2022 education legislation update. And this presentation has a lot of key highlights from the past legislative session by the Connecticut General Assembly. You can also, if you ever want a full kind of summary of everything, our website also has all of this in written narrative form, so that can be a point of reference in the future. But without further ado, we'll begin the presentation. First thing, the presentation is kind of divided into several different chapters, if you will. The first thing we'll discuss are statutory changes affecting school district operation. Then we'll move on to statutory changes affecting students, statutory changes affecting employment, statutory changes related to mental and physical health services in schools, and reminders of new policies that are required as of July 1st, 2022. And before moving on, I actually just want to take a moment to highlight bullet number 4 here, which is statutory changes related to mental and physical health services in schools. This was a huge focus of the legislature this session. So even though we'll cover this in depth in the latter part of the presentation, you'll see some strains of the legislature's emphasis on mental and physical health services for kids. That's probably sparked in large part by the pandemic and the post-pandemic effects that we're seeing with students across the state. But I think that it's important to have that lens as we learn about a lot of the new legislation, that was one of the main emphases of the legislature this past year. Okay, so as I mentioned, we'll start with statutory changes affecting school district operation. You'll see a lot of these things kind of overlap with changes affecting employees and students, but the big bucket here is school district operation. The first legislative change that I wanted to highlight is that the legislature made permanent a law that had been enacted during the pandemic regarding remote Board of Education meetings. So as you guys are probably well aware, under the Freedom of Information Act, public agencies, including boards of education, have to make their meetings open to the public unless they're held in executive session. So last year, the Connecticut General Assembly passed a law allowing public agencies until April 30th, 2022, to hold public meetings that could be accessible to the public through electronic equipment or through electronic equipment in conjunction with an in-person meeting. So we kind of commonly refer to those as remote Board of Education meetings or hybrid meetings. This past session, so there was a trial period, right? The legislature in 2021 passed this law saying until 2022, you can hold your meetings remotely. This past session, they revisited the topic and passed a new law, which removes that April 30th, 2022 sunset date. And it now allows public agencies, including boards of education, to continue to hold remote and hybrid meetings as long as they comply with requirements under existing law. And for anyone who's interested, the Freedom of Information Commission on their website has a primer that outlines those very specific rules that are in addition to the public meeting rules when meetings are held remotely or in hybrid fashion. Importantly, the new law also requires public agencies like boards of education to provide its members, so that means its board members, the opportunity to participate by means of electronic equipment. So when you have remote board meetings or committee meetings, they can be held remotely or in hybrid fashion for the public, but if a board member or committee member wants to participate remotely, they have that as a matter of right under the new law. Okay, so just to get your brains thinking, I thought we'd start out with a scenario this morning. And as Alicia mentioned, I'll read through it. I'll give you a minute to think about it, and then I'll kind of walk through some of the considerations that are in play by the scenario. So in this scenario, scenario number one, we have September arrives and students are back to school. Everyone's looking forward to what looks to be a normal school year, fingers crossed. But as September comes to a close, student absences skyrocket, and there are news reports that COVID-19 cases are again on the rise. Principals throughout the district begin receiving requests and some demands from parents that their children be allowed to engage in remote learning. The school has the capacity to do it, they argue, and then we all know that schools were able to pivot in a remarkable way in March of 2020 and now has the capacity to provide remote learning. And they're concerned about keeping their children engaged in learning, given the toll the pandemic has taken the past couple of years. So the question presented by this scenario is, can your district allow students to engage in remote learning? And does it matter what the reason is for the request? In other words, does it matter if the parents just request it as a matter of preference, or if a child is sick, or if there's a fear of contracting COVID, or if there's a vulnerable family member at home? Does it matter why the parent has submitted that request? So I'll give you a minute to think about it. And we may be past the point now that we're in September, but I know a lot of districts in August were getting these requests. And I think what's important to know here is that remote learning, unlike during the pandemic, when the executive orders kind of set out the rules of the road and also granted to the State Department of Education considerable authority to issue binding guidance in this area, all of that authority in those executive orders expired as of June 30th, 2022. And so now for remote learning, the rule of the day is that school districts can offer remote learning this year, but only for students in grades 9 through 12, and only if it's pursuant to a board policy that meets certain statutory requirements. And it really doesn't matter what the reason is for the request. Those are the rules that apply across the board. So we've seen this move, right, from providing remote learning and even public health guidance and DPH guidance in terms of when kids can and can't attend school, to now kind of going back to a new normal. And we'll go through some of those rules for remote learning just quickly. Remote learning, as I'm sure you've all been very familiar, is defined by the law as instruction by means of one or more internet-based software platforms as part of a remote learning model, affectionately known as Zoom School. And last year, so in 2021, the General Assembly passed legislation allowing boards of ed to authorize remote learning for the school year beginning July 1st, 2022, this year, but only for students in grades 9 through 12, and only if the district provided instruction in compliance with the State Department of Education standards for remote learning, and only if boards of education adopt a formal board policy regarding the requirements for student attendance during remote learning in compliance with State Department of Education attendance guidance. So there's pretty strict standards, and those State Department of Education standards for remote learning were released earlier this calendar year, and they're pretty extensive. So for any districts choosing to offer remote learning, they must meet these remote learning requirements. This year in 2022, interestingly, the General Assembly expanded the authority of boards of education to allow remote learning for students in grades K through 12, but that doesn't go into effect this year. It begins with the 24-25 school year. And again, it would have to meet the same requirements for being pursuant to a board policy. That includes requirements that are in compliance with the attendance guidelines set forth by the State Department of Education and the remote learning guidance. The other thing the new instruction said, if you offer remote learning, and you don't have to offer it, but if you do, the remote learning definition that we just discussed remains unchanged. It's still Zoom School, but effective July 1st, 2022, this year, you have to prohibit dual instruction. And that means districts can no longer allow the simultaneous instruction by a teacher to students who are with students in a classroom and students who are engaged in remote learning via some form of internet platform as part of a remote learning model. So that is now prohibited. One important thing to flag here is that even though this legislation sets out kind of the restrictions on remote learning that's part of a remote learning model, boards of education and school districts should also be mindful that remote instruction might be required in other circumstances pursuant to other laws, such as the Individuals with Disabilities in Education Act and Section 504 of the Rehabilitation Act under certain circumstances. And that's something that would be determined via a PPT process depending on an individual student's needs. Alicia, any questions so far, or are we good? We're good. Okay. I'll try and stop periodically. Alicia's helping me monitor. All right. So that's enough for remote learning for now. Another thing, and you might remember this from last year, is that last year, the General Assembly passed legislation directing the State Department of Education in collaboration with the State Educational Resource Center to develop a model curriculum that boards of education may use for grades K through 8. Very importantly, this does not mean that districts have to use this model curriculum. It's a model curriculum that can be used as a resource for boards of education and school districts. This law, there's a new law passed this year that basically extends the deadline by 1 year to January 1st, 2024. So instead of being on the lookout for it this January, we'll be on the lookout for it the following January. And just to flag for you, the model curriculum, and I can kind of see why they extended the deadline for a year. It's quite hefty. There's a lot of important topics. And the model curriculum, once it's released, will address the following: Native American studies, Asian American and Pacific Islander studies, LGBTQ and other sexual orientations and gender identity studies, climate change, personal financial management and financial literacy, military service and experience of American veterans, civics and citizenship, principles of social emotional learning, and racism. To be honest, I'd like to be part of that committee developing that curriculum because it's just lots of food for thought there. But again, it's a model curriculum. It does not have to be adopted by boards of education throughout the state. There are some changes, however, related to curriculum that boards of education have to follow. The first one I'm going to talk about today is curriculum changes related to Asian American and Pacific Islander studies. So as you likely know, Connecticut state law in section 10-16B of the Connecticut General Statutes outlines the program of instruction that must be offered by public schools throughout the state. And beginning with the 25-26 school year, so we always appreciate when there's some lead time, when the change doesn't become effective within a month. So this is nice that you have some time to comply. This new law requires boards of education to include Asian American and Pacific Islander studies in their social studies curriculum. One question that we've gotten is whether there are any specific grade levels that are identified where this must be covered. The new law does not specifically say what grade levels it has to be covered in, but we'll look for further guidance from the State Department of Education on that. The new law does, however, lay out some requirements, and it supplements recent requirements that include African American and Black studies and Puerto Rican and Latino studies, as well as Native American studies. As far as Asian American and Pacific Islander studies, these studies must include a focus on the history of Asian American and Pacific Islanders throughout the state, the region, and the United States, and specifically their contributions in the following areas. First, their contributions towards advancing civil rights from the 19th century until today. Second, as individuals in government, the arts, humanities, and sciences. And third, as communities to the economic, cultural, social, and political development in the United States. And as I mentioned before, this will be a topic in the model curriculum that's coming out, that's going to be issued by the State Department of Education. Boards of education can utilize those materials that are going to be made available by the State Department of Education, or they can use materials through other appropriate public or private sources. Another curriculum related change was passed by Public Act number 22-118, and it requires that beginning July 1st, 2023, so less lead time than the other requirement, this new law requires rather than allows climate change to be taught as part of the science requirement in a public schools program of instruction. So pursuant to the new revised statute and the newly revised Section 10-16B of the Connecticut General Statutes, the State Board of Education has to make available curriculum materials that include climate change, and those materials have to be consistent with next generation science standards. All right, so we have a, oops, sorry. That was a preview of coming attractions there. I went too fast. I'll pause here for a second just to see if any questions have come in or if we can keep going. All right, we're good. All right, so we have another scenario, some food for thought. I will read through it, give you a second to think about it, and then we'll walk through some of the considerations. So at the beginning of next school year, there's an open house at the high school for parents to learn about the curriculum. The following day, an angry parent emails the principal stating that he wants his child to be exempt from any instruction on climate change, family planning, or sexuality, because that type of instruction is against his family's religious beliefs. And so the question comes up, how should the district respond? And I will say, this is not entirely a hypothetical. It's a combination of many questions that we've gotten over the past year especially, but probably even longer than that. But I think I just wanted to provide kind of a broad backdrop, which is generally speaking, school districts have wide authority to regulate the curriculum and decide what curriculum is appropriate for their students. And there's a lot of court cases and a line of court cases that establishes that. However, there are some topics that are subject to exemption. And in Connecticut, there are statutory exemptions which grant parents and guardians the right to exempt their children from instruction in certain areas. And those areas are HIV/AIDS instruction, firearm safety instruction, sexual assault and awareness prevention programs, family life planning, and also dissection, which actually is something I wanted to be exempted from when I was in high school. I'm not a big science person. If a parent requests in writing that their child be exempt from one of those very specific areas, then as a matter of right, the student has to be exempt from instruction in that area, and in certain circumstances has to be given an alternative assignment. No matter what, can they be marked as unexcused or anything along those lines. In terms of requesting an exemption because it's part of the family's religious beliefs, we have seen that some districts have policies that talk about this request for exemption based on for religious reasons. And so I would recommend that you would familiarize yourself with your district's policies. And if you do have an exemption for religious reasons, it would be very important to apply that policy consistently so that everyone is subject to equal protection of the law and all similarly situated individuals are treated similarly. But apart from that, it would depend on whether an exemption was fell within one of those 5 categories that I just highlighted or not. Okay. All right, now to the sneak preview slide that I had flashed up before. Juneteenth. I don't know how many of you were in school last June 19th, but this is something that we got questions about last June because the law was passed before June 19th rolled around. And the Connecticut General Assembly amended the list of state holidays to include the 19th day of June, which is now called Juneteenth Independence Day. The law specifically provides that school may be held on this state holiday, so you don't have to close schools on June 19th. But if you do hold school, the school district must hold a suitable non-sectarian educational program in observance of the holiday. So if you do next year, if your calendar runs beyond June 19th, you can choose to have school, but if you do, you have to have some kind of ceremony or educational program in observance of the holiday. Some things that have come up, some schools have considered closing school for students on that day, but still having offices open for administrators or custodial staff, other staff. So that's an option too. There's a lot of different ways you can recognize Juneteenth in accordance with the law.
Dori, we do have one question regarding back to the conversation about climate change in Asian American and Pacific Islander studies. Are there grade levels associated with those requirements?
Not in the statute, there aren't, but it is supposed to be throughout the curriculum. I did hear from, I have heard through the grapevine that someone at the State Department of Education had said it should ideally be kind of strung throughout the K through 12 curriculum, but we're waiting to see further guidance from the State Department of Education on that.
Okay, thank you.
All right, good, let's keep going. Okay, so this is, I had said before, we always appreciate when there's a little bit of lead time with the new law. You know, they give us till 2023 or 2024 to comply with something. This new law regarding paraeducator professional development goes into effect this year and became effective July 1st, 2022. So as most of the people on this call probably already know, the general statutes already require boards of education to establish a professional development and evaluation committee. Under the new law that was just passed, beginning this school year, the Professional Development and Evaluation Committee must develop, evaluate, and annually update a comprehensive local PD plan for paraeducators in the school district in accordance with statutory requirements. And there are many. We'll go through some of those statutory requirements, and they're discussed in even more detail in that document that I had referred to earlier. And Alicia, I can send you a link to that document to send out to participants after. I'm sorry, I should have had it in the window here for you, but I'll send it so you can share it with everyone after the fact. So beginning again with this school year and annually thereafter, the law also says that paraeducators must participate in the program of PD at no cost. So it has to be something that paraeducators basically attend during their paid time and at no cost to them. Among many other requirements, the program for paraeducators has to be at least 18 hours in length. And the majority of the time has to be spent in a small group or individual instructional setting. So I know that this is something that a lot of districts throughout the state have been grappling with how to kind of include these requirements in their PD program this year. Here are some of the other requirements that are set forth in the statute. So the PD program for paraeducators has to be comprised of professional learning that, one, is aligned with rigorous state student academic achievement standards. 2, is conducted among paraeducators at the school and facilitated by principals, coaches, mentors, distinguished educators, or other appropriate teachers. 3, occurs frequently on an individual basis or among groups of paraeducators in a job-embedded process of continuous improvement. And 4, includes a repository of best practices for instruction methods developed by paraeducators within each school that's continuously available for comment and updating. As if that weren't enough, you also have to make sure that the principles and practices of social emotional learning and restorative practices must be integrated throughout the components of the program. So like I said, the statute has a lot of very specific requirements for the PD in addition to kind of those baseline requirements that it has to be 18 hours in length and provided at no cost to the paraeducators. Okay. So we have another scenario just to keep you guys engaged and thinking. In this scenario, the PD committee and the administration have been working hard to plan for professional development for teachers at the start of the school year. They have heard that starting this year, paraeducators also need to participate in PD, but it's a little late to require them to attend training that occurs before school starts in August. So instead, the district plans for paraeducators to attend professional development days held throughout the year, thinking it will be easy enough to add paraeducators to already planned programming. So the food for thought here is, first, will that plan work? And second, what if the paraeducators refuse, citing practical and contractual matters? So I'll just give you a second to think about that or read. Some people are visual learners, I know, instead of auditory learners. Give you a second to read the scenario and then we'll talk about it. Okay, so as we just discussed, you can't just add, under the law, there are specific requirements for what the PD training for paraeducators has to include, including small group instruction and, emphasis on kind of best practices for instruction that paraeducators use. So just incorporating paraeducators into the already planned programming for teachers or other staff won't meet the requirements of the statute. And so it will be important for the PD committee to look at their professional development planning and determine how they can make planning and programming that's specifically tailored to paraeducators that meets the requirements. The good news is it didn't have to be before the start of the school year. And in fact, it's supposed to be provided on an ongoing, comprehensive, continuous basis. So it can be kind of sprinkled throughout the school year. So that is a helpful element, but it certainly is a sea change in the professional development requirements for paraeducators. Regarding what if paraeducators refuse, citing practical and contractual matters, the new law does say that paraeducators have to participate in the program. But depending on how what your contract says for paraeducators and what the practice is, whether paraeducators already stay at school during PD time or not, there certainly will be contractual and practical concerns that need to be worked out this year and determining what their schedule will be, whether paraeducators will be kind of pulled from the classroom in order to engage in the paraeducator development. And if that's the case, what will happen to the duties that they're supposed to be covering, if they will be required to attend PD days that they weren't required to attend in the past. There are definitely a lot of practical and contractual concerns at play, and those will vary greatly depending on your school district and the system in place. But the bottom line is that paraeducators under the law do have to meet this requirement, as well as boards of education providing the professional development for their paraeducators that are employed throughout the district.
Dori, back to the climate change
Sure.
curriculum. Is there, there was a question, I think you might have mentioned this, but the timeline for implementation for that curriculum?
I believe it's July 1st, 2023.
Okay.
I can do a little cheat here and make sure, double check. Yep. July 1st, 2023. All right. Sorry if that made anyone dizzy, but I figured I knew I had the information on the slide. I might as well double check right while we had it. So yeah, so that starts in 2023, that requirement. Not this year, at least. So, okay, good to move on. Yeah, okay. Thank you, Alicia. Okay, there are some more changes to the law regarding paraprofessionals. And just so you know, we've used paraprofessionals in these slides because the law requiring attendance at PPT meetings refers to paraprofessionals, whereas the PD law refers to paraeducators. Not sure why. I think it really refers to the same group of people, but we like to stick as closely as possible to the language that is used in the statute. But I know that question has come up. Why do we sometimes refer to paraeducators and sometimes to paraprofessionals? Bottom line is we refer to what the law, what the statute says. So current law requires boards of education to notify parents of their right to have the paraprofessional that's assigned to their child attend a PPT meeting. And I say current law, but this was a new requirement that went into effect last year, but it has been in effect in the past year. This year, the Connecticut General Assembly kind of revisited that new requirement and placed additional requirements on the right of a paraprofessional to attend the meeting. If a parent has exercised their right and requested that the paraprofessional attend the meeting, then the board has to provide the following. And I should backtrack for a second. The boards of education are required to notify their parents of their right to request the paraprofessional's attendance at the meeting. So if the parent says, yes, we want the paraprofessional to attend, and another question that's come up, it's the paraprofessional who's assigned to their child, not any paraprofessional who works in a classroom. If the parent says, yes, we would like the paraprofessional to attend the meeting, then the Board of Education has to provide adequate notice of the PPT meeting to the paraprofessional, obviously adequate notice to the parents, but also to the paraprofessional so that that paraprofessional can adequately prepare for the meeting. The Board of Education or the district also has to provide training upon request to the paraprofessional on the paraprofessional's role at that PPT meeting. So these are additional requirements that add on to the requirement that was added to the law last year. Okay, so switching gears a little bit now from kind of the paraeducator and paraprofessional related legislation, the next few slides are going to talk about the statewide sexual abuse and assault awareness and prevention program. So as mandated reporters, you are probably all really familiar with this program, and you probably all know that by law, DCF has to identify or develop a statewide sexual abuse and assault awareness and prevention program for use by boards of education. So previously, only teachers were required to participate in the program. There was a new law passed this past legislative session that now requires no later than July of next year, so July 1st, 2023, it requires DCF to revise this sexual abuse and assault awareness and prevention program to also include a bystander training program and an appropriate interaction with children training program. So now this DCF program is going to have 3 components, which I think is going to be actually really helpful for boards of education, because I think there's lots of beyond kind of what is sexual abuse and assault awareness and prevention. I think there are lots of other related issues that will be important for teachers and other employees of the school district to receive training on. In addition, and this is a new change, the newly developed program must be for all school employees, not just teachers. And that's the term as defined in the Connecticut General Statutes. That term is basically every single employee of the school board, as well as certain contracted positions that have direct contact with children. So that's a big change. Not only the content of the program that has to be provided by DCF, but also who it applies to.
Dori, can we go back for a second? You had a question on if a child regularly works with 2 or more paraprofessionals and does not have a single person assigned to them.
I would say,
I think that was going back to PPTs.
Yep, I would say if they regularly work, if it seems to me like those are both assigned to them. I think that's different than a classroom where there's a paraprofessional in the classroom that has oversight of the entire classroom. In that situation, if they have 2, like, you know, someone in the morning and someone in the afternoon, I think the fairest reading is probably to allow both of them to attend the meeting, but it might be fact dependent. If someone just serves as kind of a substitute paraprofessional, then that might not be the individual who's regularly assigned to the child.
Thank you. And then can we jump back to DCF training?
Sure.
Does that apply to school bus drivers?
So certainly it applies to school bus drivers if they're employed by the district. Most bus drivers are contracted, right, through companies. And so I think that that's going to be something that needs to be negotiated with the bus companies in terms of whether that training is required. And we'll have to take a look at whether they have direct and regular contact with the children. We're waiting State Department of Education guidance on that. I think there's a likelihood that it will apply to bus drivers, but we will see. Good, very good question. Okay, good. Yeah. All right. So staying on the very important topic, you know, of protecting kids. There were also some changes in the law regarding training on child abuse and neglect. So the new law says that on and after July 1st, 2023, so again, next year, each school employee has to complete the training provided by DCF regarding the prevention and identification of and response to child sexual assault and abuse, and the new Price-Stender training program, and the new appropriate interaction with children training program. So that has to be completed beginning next year. And there have to be repeats of that training every 3 years in order for employees to stay in compliance with the law. The new legislation also addressed Board of Education policies and information regarding child abuse and neglect. So under existing law, boards of education are already required to adopt a written policy for mandatory reporting by school employees of any suspected child abuse or neglect. And the policy has to be distributed annually to all school employees. The new law requires that this annual distribution be done electronically, probably to both go green and also to ensure, you know, a record that the requirements are distributed to all employees. The new law also has additional requirements for policies regarding child abuse and neglect. And starting with this year, boards of education must distribute electronically a copy of the guidelines on identifying and reporting child sex abuse that have been developed by the Governor's Task Force on Justice for Abused Children to all school employees, board members, and parents and guardians of enrolled students. And then starting next year, so 23-24 school year, boards of education must also distribute electronically information on DCF's Sexual Abuse and Assault Awareness Prevention Program, and that information has to be distributed to all school employees, board members, and parents and guardians of enrolled students. Okay. All right, behavior intervention meetings. This is a new requirement under the law that goes into effect this year. Again, one of our favorites when it comes in, but this is a little bit easier to comply with than having 18 hours of brand new paraeducator professional development. Under this law, beginning this year, like I mentioned, any teacher has the right to request a behavior intervention meeting with the school's crisis intervention team if a student's behavior has caused either a serious disruption to other students' instruction or self-harm or physical harm to the teacher, another student, or staff who are in the teacher's classroom. So the crisis intervention team has to hold the meeting, and its participants must identify resources and supports to address the social, emotional, and instructional needs of the student. So that is really the only parameter of the law about what this crisis intervention team meeting must address. But we have advised districts that if this is happening, this is probably also going to trigger child find obligations, and you might want to, it might be necessary to do additional evaluation of the student depending on what the behaviors at issue are. Okay, switching gears again. This is a totally new requirement in the law, and interestingly, the law directs the Office of Workforce Strategy, not the State Department of Education, to work with the DECD, and it requires the Chief Workforce Officer, in consultation with the Commissioner of Education, the Executive Director of Technical Education and Career Systems, and the Labor Commissioner, to develop by July 1st of 2023 a model student work release policy. And I think that this is really interesting because a lot of districts are grappling with how to meet those mastery-based diploma assessment requirements and kind of internships for course credit, and how to release students from kind of academic requirements to do that work. Right now, there's not a lot of guidance from the state about how to do that. There's a tremendous amount of flexibility, which we've seen. I think that this new law, as well as a few others we'll talk about in the upcoming slides, signal that the State Department of Education might get more involved in this area. And perhaps it's because of that new mastery-based diploma assessment, but it's something to be aware of. And this new model student work release policy has to be developed by next summer. And then the following year for 24-25, for every school year thereafter, the board has to adopt the model work release policy. So it remains to be seen exactly what it will cover and exactly what it will say. But I think it's an interesting development, especially in light of more districts wanting to have kind of internship credit and those types of things available for their students. This kind of goes along with that same theme. There was new legislation regarding the pipeline for Connecticut's Future program, otherwise known as the Pathways program. And this new legislation requires the State Department of Education, in collaboration with the Department of Labor, to administer the Pathways program, along with local businesses, to create on-site student training opportunities for course credit. It also requires the State Department of Ed to assist boards of education in enhancing or establishing partnerships with childcare providers, early childhood education programs, or mental health services, and additional fields such as manufacturing, computer programming, or culinary arts, and one or more local businesses to offer a Pathways program. So right now it's requiring the State Department of Education to administer this program and to provide assistance to boards of ed. Again, we'll see how this develops and where this goes in the future, but this is kind of a new authority for the State Department of Education to be administering the pipeline for Connecticut's Future program. Just a little bit more detail about the pipeline for Connecticut's Future program. The statute specifically requires that such program must help students obtain occupational licenses, participate in apprenticeship opportunities, and gain immediate job skills, has to provide specific industry-specific class time and cooperative work placements, on-site apprenticeship training and course credit and occupational licenses to students upon completion, and may, upon graduation, lead to a diploma, credential, certificate, or license in the applicable field. So there's a lot more requirements than we've seen before. Okay, a couple more things for school district operations. I'm sure this is in large part due to COVID and everything we've learned about ventilation and HVAC systems, but the legislature passed a new law this session that requires all boards of education before January 1st of 2024, and then every 5 years, to provide for a uniform inspection and evaluation of the HVAC systems within each school building. That inspection report then has to be presented at a regularly scheduled board meeting to the board, and it has to be posted on the board's website and each individual school's website if the schools do have their own websites. some more fun topics. Student transportation contracts. At least we get a bright, pretty, picture for this one with the school buses. But as you probably already know, under current law, boards of ed may enter into contracts for student transportation, but only up to 5 years. Under the new law, beginning this October 1st, boards of education may enter transportation contracts with bus companies for up to 10 years instead of 5, but only if the contract includes transportation provided by at least one zero-emission school bus, as defined in the law. So this new law allows for longer transportation contracts if they meet certain requirements, but there's more. The new law also requires an eventual transition to zero-emission school buses. I have heard in giving this presentation to other districts, some people say, oh, 2040, I'll be retired by then. I don't have to worry about it. But this is a preview of coming attractions. So school buses in school districts that are entirely within or that contain what's known in the law as an environmental justice community must be 100% zero emission by January 1st, 2030. So that's pretty soon. And an environmental justice community, it refers to a US Census block group where there's 30% or more of the population with low-income persons who are not institutionalized and have an income below 200% of the federal poverty level. So it's really targeting kind of low-income communities and saying that in those communities, we need zero-emission school buses by January 1st, 2030. Environmental justice communities are also distressed municipalities as defined in another section of the law. So it'll be important for you to know if your district is required to meet these requirements by January 1st, 2030 or not. School buses in all other school districts that are not within or contain an environmental justice community must be 100% zero emission or use alternative fuel buses by January 1st, 2035. And then must be 100% zero emission only by January 1st, 2040. So no matter what, by January 1st, 2040, this new statute directs that all school buses and school districts have to be zero emission within, I'd say, 18 years. So that'll be a big change. All right, that was the first section, the longest section. So now we're gonna move on to statutory changes affecting students. And like I said, there's some overlap with all of these categories, but these primarily affect differences that students will see in the school year. And the first thing, I should go back and stop. Any other questions, Alicia or Tiffany? Are we good? We're good. Okay. All right. So thank you. All right. So moving on to statutory changes affecting students. As you probably already know, boards of education are required to adopt policies and procedures that contain specific requirements for truant students. And truant students are students who have 4 or more unexcused absences a month or 10 in a year. So that's already a current requirement. The new law amends what these board policies must include. And the new law says, I'm actually going to start with number 2 in the list because this is the one that goes into effect this year. So in effect this year, Board of Education policies or procedures must include notice to the parent or guardian of a student who is truant of the existence and availability of a 211 info line program and other pediatric mental and behavioral health screening services and tools that are described in the statute. So that's a fairly easy one to comply with. If you have identified a student as truant, you need to provide notice about to the parents and guardians of those students of these available resources. In addition, moving forward, so starting for the 23-24 school year, the State Department of Education has also been directed by the statute to develop a new truancy intervention model that accounts for mental and behavioral health or a similar truancy intervention plan that meets statutory requirements. So that's supposed to be coming forth by September 1st of next year. And then the school districts will have to review that and incorporate those requirements in their truancy procedures. In addition, for the 23-24 school year, school district policies and procedures also need to include a requirement that an appropriate school mental health specialist conduct an evaluation of each child who's truant to determine if additional behavioral health interventions are necessary for the well-being of the child. So at the beginning, we talked about how the legislature made a lot of changes that address mental and behavioral health services for kids, and this is one. This kind of goes hand in hand with the attendance issues that we've seen since the pandemic in a lot of districts. So I think the legislature is trying to address two things, kind of two birds with one stone here, by addressing kids who are absent a lot and who to the extent that they're truant, and also how can we support those students who are experiencing kind of those difficulties. Okay, this next series of slides is a big mouthful, so so hopefully I won't trip over the words too much. Withholding time devoted to physical exercise as a form of student discipline, otherwise known as recess, but it's not referred to it in the law that way. So the general statutes, section 10-221.0, already requires each Board of Education to include at least 20 minutes of physical exercise in each regular school day for elementary school kids, unless it's been determined otherwise by the PPT in accordance with the IDEA. Current law also allows boards of education to include an additional amount of time beyond the 20 minutes required for physical exercises. And you can identify that as time devoted to undirected play during the regular elementary school day. The new law really kind of provides a lot of detail about what your school policies have to require for restricting or preventing that recess time. And for the school year beginning this year, so this year and every school year thereafter, there are new statutory requirements. The big picture is that every Board of Education has to adopt a policy regarding when, as a form of discipline, a school employee may prevent or otherwise restrict a student from participating in the entire time devoted to physical exercise in the regular school day. And there are a lot of requirements that we'll walk through. This is probably one you're going to want to look back on because there's a lot of particulars. So the Board of Education policy and procedures must allow school employees to prevent or restrict that recess time when a student poses a danger to the health or safety of other students or school personnel. So you're allowed to restrict or hold back from recess in that circumstance, or if the restriction or prevention of recess time is limited to the shorter period, if there are 2 or more periods devoted to physical exercise, as long as the student is still allowed to participate in at least 20 minutes of physical activity during the school day. So again, these kind of new requirements of when you can restrict or prohibit time devoted to physical exercise, again, is related to children's mental and physical health. These changes in the law are pretty regulatory, but the main kind of emphasis is to let kids get outside and play.
Dori, we have 2 questions.
Sure.
The first one, is it safe to assume that elementary is through grade 5?
I think it might be through 6 under the law. Alicia's nodding. Secondary, I think, is 7th and up. So K6 is really elementary, but I can double check that to make sure it's something a statutory requirement, or if it's, I will get back to you on that to ensure.
Okay. And then, does middle school need to provide recess, or can we withhold for discipline? Students have PE every other day.
So this law specifically talks about elementary school and the restrictions on withholding recess time for elementary school students. So these restrictions are going to apply to elementary kids.
Okay. And then if you have a half day, do you still need to have 20-minute recess?
Good question, because it's in the regular school day. So I would have to look up and see if the regular school day if it distinguishes between half days or not. These are good new questions I haven't gotten. I'm going to write that down. All right, well, let me go through kind of when you cannot restrict recess for elementary school kids, and I will look back, but elementary generally is K through 6. Regular school day, I'm not sure if the law distinguishes between half days or not in terms of whether you still need to provide recess, but I will look into that. So thank you for those questions. The new law requires that the policy, the Board of Education policy regarding restriction or prevention of time devoted to physical exercise says that such time can only be restricted once per week, unless it's because the student poses a danger to the health or safety of other students or to school personnel. So that's one of the strict limits. The policy cannot include provisions that are unreasonably restricted or punitive, and it cannot allow prevention or restriction of time devoted to physical exercise if the student doesn't complete their work on time or as a result of the student's academic performance. So this is a new requirement in the law saying you can't withhold recess because they didn't finish their assignment or because they need kind of extra help with academics. The other thing that has to happen is the policy has to distinguish between discipline that's imposed before the time recess begins or physical activity begins and discipline imposed during such period, because there's probably different considerations at play. We can all imagine some things that might happen out at recess that need to be addressed in the moment. And the policy also has to distinguish between discipline that prevents or otherwise restricts a student from participating in the physical activity period prior to when the time begins, and uses methods to redirect a student's behavior during the time devoted to physical exercise. So that's, the requirements are pretty prescribed, and there's a lot of new requirements of when you can limit recess. All right, so we do have a scenario, and it's 5th grade students at the elementary school regularly get 20 minutes of recess after lunch. There's one student in the 5th grade who never finishes her classwork in the morning because she's off task. Instead of going to recess, she's required to return to the classroom to finish the work from that morning. This happens multiple times a week. Sometimes she finishes her work in only a few minutes, then she goes out to recess to rejoin her friends, but often she takes the entire 20 minutes to finish her work. The teacher is sympathetic that the student doesn't get to enjoy recess with her friends, but the student's struggling academically, and the teacher believes it's more important for her long-term learning that she finish her classwork each day. So the question is, under the new law, can the teacher require the student to miss recess to finish her work? And here she can't, because it's for academic concerns or to complete missing work. And the new law specifically says you can't restrict that time period for those reasons. And as for circumstances where this might be okay, if the student has an IEP and the PPT has determined that there's an alternative schedule kind of for her that would be appropriate, then that might be a circumstance where this is okay. And the new statute specifically addresses that. Okay, so another thing with special education, this slide has the one that has gotten the most cheers. I'd say they get an A+ on this one based on the feedback we're getting. The legislature passed a new law which states that beginning this year, the State Department of Education and boards of education have to use the term emotional disability instead of emotional disturbance when administering and providing special education. So I know that that's something that's been welcome by a lot of administrators, because I think it more accurately reflects kind of what's happening with some students. And I've also heard, some relief that it's still the same abbreviation, ED, so it makes it an easy change. The law also does specify that term, the new term emotional disability, will have the same meaning as emotional disturbance as in the IDEA. So there won't be any conflict there. Another change in the law revises Connecticut General Statute section 10-76A to define child as a person under 22 years of age. What in effect this does is require boards of education to provide special ed services to qualifying students until they reach the age of 22 rather than 21. And that statutory change basically conforms to the court case that was decided last summer. So districts should already be kind of accustomed to this new change. And now the statute reflects the court decision. Access to class rank is another new requirement in the law. So current law already requires that any minor student's parent or guardian can access their educational records, their medical records, or similar records that are maintained in the student's educational record or other records. as long as the information isn't privileged or otherwise protected. And the new law specifically adds access to the student's class rank as one of the things that parents and guardians can access upon request. So a couple questions we've gotten about this is, does that mean we need to affirmatively provide it to all parents and guardians, like with an email blast? Here's where your kid stands. That's not what's required. It requires access to the student's class rank, not an affirmative distribution of class rank. The other thing, interestingly, is the new law does not define class rank. And so far, I haven't found any State Department of Education guidance defining class rank, because I know a lot of districts report deciles, not necessarily numeric order. So that's something we'll be on the lookout for to see if there's any further clarification of what that means, access to students' class rank.
Dori, there was a question back to the paraprofessional PD about how paraprofessionals being defined. Does that include, is that only special education paraprofessionals or those tutors? So I didn't know if that was defined somewhere.
So it's not defined in the law, but the State Department of Education does have guidance about what, paraprofessionals need to have certain requirements. Either they need to meet the parapro requirements, or they need to have an associate's degree, or certain requirements like that. There's nothing that specifically says, I know some districts have said we have a paraprofessional contract that expands to office paraprofessionals and student paraprofessionals. In other words, people who help out on the clerical side and people who help out on the student side. My recommendation would be that if it's a paraprofessional working with students, given kind of the thrust of the legislation is to increase kind of capacity for instructional services and student support, then that would be a paraprofessional who would be covered under the law. But there is no statutory term for it, and that term paraprofessional is used differently in different districts across the state. The other thing was a question that we've gotten is, does it apply to full-time and part-time paraprofessionals? There's no distinction in the law. Like there's no, you only need 9 hours for a 0.5 para. So until we receive further guidance, it's for all paraprofessionals, both full-time and part-time.
Thanks, Dori. Question going back to class rank.
Yep.
If we do not include class rank on a transcript, do we have to report it, or is it automatic since we calculate GPA?
So I would say class rank is different than GPA. But again, there's no definition. Class rank is kind of where you would fall in the class, whether it's decile or numerical number. But I would say that that is different than grade point average, and the statutes do talk about grade point averages and weighted grade point averages. And they specifically did use a different term, class rank here. So I think that that's going to be something that districts might have to figure out, some form of class rank to provide to a parent if they request that information. But whether it has to be 1, 2, 3, 4 or top 10%, top quartile, that remains to be seen.
So the next question was, somebody asked about if they do not do class rank. So are you saying that they need to figure something out in the meantime?
I mean, they don't have it at all. No class rank for reporting.
No class rank at all.
I guess, that could be an initial response is we don't have class rank. There's none to access and see how it goes. But that's probably something to reach out to the State Department of Ed on. And I'll put that, these are good questions. I'll put that as a question. I haven't heard of any districts not having any form of class rank before. I have heard of lots of districts having decile rank instead of specific numerical rank. But again, there's no definition of class rank in the statute.
Okay. And then a couple people are asking, this particular presentation, not just the legislative summary text, it's on the website, but is this available with the scenarios?
So Alicia, do you want to send it out to participants after the fact? Yep. So okay. CAS has the presentation and can send it out to all the attendees after the presentation today. Okay. All right. All right. Menstrual products available in student bathrooms. This is a totally new one. The legislature did give boards of education a year to comply with this law, but beginning next September 1, boards of education have to provide free menstrual products in women's restrooms, all gender restrooms, and at least one men's restroom. The restrooms have to be accessible in students in grades 3 through 12 in each school under the jurisdiction of the board. So that means in every school building, in all of your women's rooms, all of your all gender rooms, and at least one men's restroom that's accessible to kids grades 3 and up, you have to provide free menstrual products. Importantly, it has to be done in a manner that doesn't stigmatize any student seeking any menstrual products pursuant to guidelines to be posted on the DPH website. We're hopeful that the DPH comes out with some additional guidelines. I know a lot of districts are struggling with how to do this for elementary school kids. And there's a lot of discussion going on about that. So I know people have been talking about wall dispensers and things that can do it kind of in a discreet way that hopefully won't create too much disruption. But it'll be interesting to see what the DPH guidance is on that. And again, boards have till next year at least to figure this part out. Okay, information regarding technical education in career schools. So all school districts are already required to inform middle and high school students and their parents about the availability of vocational, technical, and post-secondary education and training at tech ed and career schools, as well as agricultural science and technology education, so VOAG programs. The new law now specifies that not only do school districts have to provide this information, but specifically school counselors have to provide this information, and the information has to be made available on the board website. All right, so that was it for changes affecting students. I think we're doing pretty well on time. We're about halfway, at about halfway mark. So we'll keep going. The next set of slides has to do with statutory changes affecting employment. So we'll go through some of these. Some of these you might already have noticed in your schools. All right, the first is a minimum duty-free lunch period for teachers. So the law already requires, like prior to this change, that all professional certified employees of the school district who work directly with children must have a guaranteed duty-free period for lunch. I know a lot of administrators chuckle and say, there's no way I've ever had a guaranteed duty-free lunch period in all my years, but it is the requirement under the law. So the law was revised this year and now requires, effective this school year, that the period be uninterrupted and that it be at least 30 minutes in length. Or if more time is allowed in the CBA, then that at least that amount of time. So I know that this is something that school districts throughout the state, for some, it hasn't been a problem because teachers already have had a half an hour lunch period. For some, if they've had 25-minute lunch periods that match the high school wave, it's been a little bit trickier. One thing to point out is the statute does not say like any specific time of day that the lunch period must be held. So districts are trying, depending on the situation with their own CBAs and their own kind of schedules. I know there's been a lot of kind of legwork trying to figure out how to comply with this law. Another statutory change affecting employment, and I think this is one. This is another one that's gotten some cheers because it makes the professional educator certification a little bit more flexible and last a little bit longer. So that's something that's been welcomed by a lot of educators throughout the state. The new law amends each of the 3 levels of public school teaching certification. The first, initial educator certificates are valid for 3 years, and there's already some possible exceptions in the law. Under the revised law, the Commissioner of Education can reissue that initial certificate to anyone who holds the certificate but hasn't taught under it, as long as the certificate holder demonstrates satisfaction of the eligibility requirements that were in place when it was originally issued. So there's some flexibility there. Regarding provisional educator certificates, they are valid for 8 years. Prior to the change in the law, there was no renewal option, but under the new law, the Commissioner of Education can reissue the provisional certificate, again, if the holder can show that they meet the preparation and eligibility requirements that were in place when it was originally issued. So again, a little bit more flexibility. And regarding professional educator certificates, they've always been valid for 5 years and renewable for 5-year periods after that. The new law extends that initial validity and the renewability period to 10 years each. So again, a little bit more flexibility. Okay. Some additional changes regarding teacher certification law review. This law, a lot of times what the General Assembly does is they establish a task force, or they charge with the State Department of Education with reviewing and reporting on something, and that signals kind of changes that will come in the following legislative session. So this one's an interesting one because under this new law, the State Department of Education is required to review the state teacher certification statutes and regulations and submit a report and recommendations to the Education Committee by next January. So one of the things that the State Department of Education must do is identify obsolete provisions, evaluate the effectiveness of existing requirements, and analyze whether any of the laws create a barrier to entry or undue hardship for either teacher candidate recruitment or retention and reciprocity, or whether there are any barriers to addressing student academic needs. So this likely was spurred by the fact that Connecticut, many districts in Connecticut are seeing a teacher shortage and having difficulty hiring. And that's something I think that's happening nationwide. I think there's a lot of factors at play, but of course, like after the pandemic, there's been a lot of people leaving the profession. So this signals that the state is looking to kind of revamp or maybe make more flexible some of the teacher certification requirements. And we'll see what happens after this report and recommendations.
Dori, can we pause for a second? Is
Sure.
the change to the professional certificate for 10 years, is it retroactive or beginning with the next renewal?
No, not retroactive. It's not retroactive. So it'll be for the next renewal. Did I skip one? No. Okay, there we go. Sorry. All right. So career and technical pathways instructor permit. This, again, builds on that additional flexibility we see the state looking for people who are in the classroom. And this new law authorizes for this year and next year. So it seems like it might be a trial period. It authorized the State Board of Education to issue career and technical pathways instructor permits if a Board of Education requests such a permit. Those permits can allow people to teach part-time up to 20 classroom hours per week. So a pretty significant amount of classroom time in the following specialized fields: manufacturing, allied health, computer technology, engineering, or the construction trades. To qualify for a permit, an individual has to meet certain requirements. And those requirements include having an associate or bachelor's degree or a qualifying credential in one of those specialized fields and at least 2 years experience in the field. So this new law is basically allowing non-teachers to teach in the classroom under certain specific conditions. Again, I think it's meant to address some of that teacher shortage area, as well as the new requirements in the mastery-based diploma assessment, kind of with more flexibility and programming. Importantly, if the Board of Education employs someone with a career and technical pathway instructor permit, it's important that that instructor is provided with academic and classroom supports, because obviously their expertise will be in their field and not with kids and not with education. And there's a requirement that the Board of Education has to regularly observe, guide, and evaluate that individual's performance in the classroom to make sure the kids are getting what they need. The new law also prohibits the board from displacing a certified teacher with a permanent instructor. So in other words, you can't move a certified teacher from a classroom and replace them with someone who has one of these instructor permits. And instructors who do receive these permits are not eligible for a membership in the teacher's retirement system solely because they have this permit. If they have certification as a teacher, generally they can still remain in the TRS, but not otherwise. Okay, employee free speech. This was a statute I My understanding is that Connecticut is the second state in the country to pass this type of a law, and that they're going to be tested in the courts. So we'll see what happens. But effective July 1st, the new law prohibits employers from disciplining or discharging an employee or threatening to do so because the employee refuses to attend employer-sponsored meetings, listen to speech, or view communications primarily intended to convey the employer's opinion about religious or political matters. As public boards of education, we shouldn't be conveying our thoughts on religious matters or really, political matters anyway, but there are probably going to be some wrinkles that get played out with this, especially given the definition of political matters, which are all matters relating to elections for political office, political parties, proposals to change legislation, proposals to change regulation, and the decision to join or support any political party or political, civic, community, fraternal, or labor organization. And religious matters are those relating to religious affiliation and practice, and the decision to join or support any religious organization or association. So another change to the employment laws is expanding the list of protected classes under state statute. I would say Connecticut is a fairly is a leader, I'd say, in the nation in terms of the classes that are protected. It generally is at the forefront of expanding protected classes or cannot be subject to discrimination. There's a section of the general statutes that relate to the Commission on Human Rights and Opportunities that describe all of the protected classes and the types of discrimination that are illegal under state law. This new law adds status as a domestic violence victim to the list of protected classes. And it states that employers cannot discriminate on the basis of status as a domestic violence victim. The statute also specifies that if an employee has a physical or mental disability resulting from a domestic violence incident, that employee has to be treated the same as employees with other disabilities, like in accordance, for example, with the Americans with Disabilities Act. And the new law also, this is interesting, it amends the definition of employee to include Board of Education members, not just those who are employed, kind of compensated by the district. Under the new law, effective October 1st of this year, so starting in a couple of weeks, it is a discriminatory practice for an employer to deny an employee a reasonable leave of absence for the employee to do any of the following. First, seek attention for injuries that are caused by domestic violence, to obtain services, including safety planning from a domestic violence agency or race crisis center, to obtain psychological counseling, take other actions to increase safety from future incidents, or to obtain legal services, assist in the offense's prosecution, or otherwise participate in related legal proceedings. An employee who's absent from work under these circumstances must provide a certification that meets statutory requirements upon request within a reasonable time after the absence. That doesn't mean that the district has to seek certification, but if the district requests it, the employee has to provide it. So we have a scenario related to this one. The principal of the elementary school has heard through the grapevine that the reading specialist is having serious problems at home. Exactly what's going on is not clear, but there's definitely something happening. She's also used all of her personal days and is out of sick days. She now asks the principal for additional time off for personal reasons. So what should the principal do in light of this new law? So the biggest takeaway from this is that the principal should be referring her to HR, right? Because this is obviously a leave situation. It's best handled and must be handled by your HR professionals in the district and not by a direct supervisor. Request for leave under the FMLA is very clear that direct supervisors should have no part in administering such leave. So I would say that this is in the same category. And it is a tricky, delicate situation because she hasn't said why she needs the leave. You just know that she's out of personal days and out of sick days. So I think a human resources professional could best discuss with her kind of the status of the leave that she has run out of, but other leave options that are available and offer all sorts of leave, including the domestic violence leave that might be appropriate in the circumstance, so that the employee can share what the employee wants to share with the employer rather than kind of rushing to a conclusion or an assumption, but still at the same time complying with your obligations under the new law. So. All right, statutory changes related to mental and physical health services in schools. I know we touched on a few of these kind of with the other statutes, but here are this category specifically deals with statutory changes that are related to these issues for kids. The first thing, and I will say the State Department of Education and DCF are going to be busy after this legislative session. They've been tasked with a lot. But this new law requires DCF in collaboration with the State Department of Ed to develop by this coming January a peer-to-peer mental health support program. Once developed, they have to make it available to boards of education. The boards of education don't have to implement it, but can use it as a resource and as a model. And that peer-to-peer mental health support must provide services to assist students in grades 6 through 12 with problem solving, decision-making, conflict resolution, and stress management. So we'll be on the lookout for that starting January 1st. The Children's Mental Health Wellness Day, this actually went into effect last year. It requires the governor to proclaim May 26th of every year to be Get Outside and Play for Children's Mental Health Day, to raise awareness about children's mental health and the positive effect that being outdoors has on children's mental health and wellness. We saw this kind of with some of the statutory revisions to the recess law that we talked about earlier. I think this is important from kind of an implementation standpoint. The new law does require that at the state capitol, suitable exercises be held in order to celebrate the day, but it also says that the suitable exercises can be held in the public schools on that day, so on May 26th, or if that day is not a school day, on the prior school day, or on any day the Board of Education prescribes. In other words, boards of education have the flexibility to determine what day they want to make as the Children's Mental Health Wellness Day. And I have heard some people thinking about maybe combining this with field day or doing kind of a mental health, physical health week along with field day in order to meet these statutory requirements in a way that makes sense for their district. Starting with this year, the State Department of Education has also been tasked with providing annual notice to boards of ed about the designated day with suggestions or materials for things that you might be able to do in order to observe the Get Outside and Play for Children's Mental Health Day. Another requirement is that under existing law, boards of education already have to annually submit to the State Department of Education a strategic school profile that provides information on measures of student needs. Under the new law, as part of this student needs category, the Board of Education must also provide a needs assessment that identifies resources necessary to, 1, address student trauma that impacts students and staff in each school, and 2, the resources necessary to adequately respond to students with mental, emotional, or behavioral health needs.
Dori, there was a question about Children's Mental Health Awareness Day. Does that apply only to elementary age students? Are there any requirements for older students?
So that is for in all the public schools.
So children in the broadest sense.
Children under 18 and the 18-year-olds who are still going to school. All the students, yes.
Yeah.
And the ones who just went off to college who will still it's important for everybody. All right, family care coordinators. This is a new requirement in the law that goes into effect this school year, and it requires every Board of Education, to hire or designate an existing employee to serve as the school district's family care coordinator. So you do not have to hire a new individual for this role. You can, designate someone to assume this role for your school district. The statute does lay out the requirements, kind of in the obligations, the responsibilities, and the duties of the family care coordinator. And that individual has to work with school social workers, psychologists, and counselors, and serve as a liaison with mental health service providers to provide students with access to mental health resources in the community that bring mental health services to students inside the school. So again, this goes along with that whole focus on trying to provide mental and behavioral health supports for our kids. Another thing that State Department of Education has to get busy doing, as required by the new statute, is to develop a mental health plan for student athletes. So the State Department of Education is tasked with doing this in collaboration with the authorities governing intramural and interscholastic athletics, so CIAC, and they are tasked with developing a mental health plan for student athletes to raise awareness about mental health resources that are available to them. The statute does lay out what the plan has to include, and it has to include access to the district's mental health services team, screening and recognizing appropriate referrals for student athletes, communication among mental health services team members, management of the administration of medication for student athletes, crisis intervention services, mitigation of risk. And I thought this last one was interesting, transition care for student athletes leaving athletics due to graduation, dismissal, or suspension. I think that that kind of ties in, right, this whole idea of physical exercise, mental health, how they're all rolled into one, and during times of transition for all of our students, including student athletes, those can be difficult things for them to manage. So this mental health plan is geared to helping identify resources for student athletes to ease with that transition, and or not in the transition, even during the course of their school years. Okay, student identification cards. It requires each Board of Education beginning with the 23-24 school year, so not this year, but next year, to include the 988 National Suicide Prevention Lifeline number on student identification cards distributed to students in grades 6 through 12. When this came up, we did search the statutes to see if there was any requirement that districts provide student identification cards to students in grades 6 through 12, because our understanding is that a lot of districts have this for high schools, but not necessarily for all of these grades. We're not aware of a requirement that you have to have cards for all of these grades, but if you do, beginning next year, it will have to have this number. The hotline did launch in July of this year, so this kind of postponement won't be applicable. The National Suicide Prevention Lifeline did launch and is operational now, so that will be required. I have heard from some districts that don't have the cards for all the kids. They're thinking of some interim kind of solutions to this by including it on their student planners or in other things that are distributed to kids in all those grade levels.
Dori, we had a question with regards to the family care coordinator. Are there any specific credentials or certification or anything for that role?
There's nothing outlined in the statute for that role, but I think given the fact that their main task is to be a liaison with the mental health services, I think one of our mental health specialists or someone with that type of background would be the appropriate staff member, but it doesn't say it has to be a psychologist or a school counselor or a social worker. There's no requirement in the statute. Okay, opioid antagonists in schools. There's going to be a few slides on this one. And obviously there's been some tragedy in Connecticut, and I think this legislation is meant to address that and reflect the fact that prior to this law, the law regarding administration of medication in schools really was silent about the administration of opioid antagonists. Most schools use Narcan. So now this is specifically addressed in the law. And as you probably know, the general statutes address administration of medication in schools, and generally speaking, in most circumstances, in order to administer medication to a student, a school district has to have the written order of a qualified medical professional and the written authorization of a parent or guardian before administering such medication. The new law, which goes into effect this year, allows school nurses, or in their absence, qualified school employees, to maintain and administer opioid antagonists. on an emergency basis and without prior written authorization to students who are experiencing opioid-related drug overdoses. But under the new law, they can only do that provided certain requirements are met. And there are a lot of requirements, and we'll walk through those. First, just kind of as a background, an opioid antagonist is naloxone hydrochloride, which kind of goes by the name Narcan, or any similarly acting and equally safe drug that the FDA has approved for the treatment of drug overdose. For people who don't know, Narcan is a nasal spray. So that's how it's administered to kids or adults who are experiencing a suspected or known drug overdose. Under the new law, a school nurse or the principal so let me step back for a second. No school district is required to administer opioid antagonists in schools. This is an option, but if school districts decide to make Narcan available in their school districts to administer in the case of an emergency, these are the requirements that have to be met. So if your district decides to do it, then the school nurse or the principal has to select qualified school employees to administer the opioid antagonist. And at least one of these individuals has to be on school grounds during regular school hours when the nurse is not on school grounds. Okay, so if you're going to have this, somebody's got to be there who is trained and knows how to use it. And the qualified school employees are the individuals who are trained and knowledgeable on how to administer the opioid antagonist when the school nurse is absent or unavailable for another reason. So the list kind of who can be a qualified school employee to serve in this role, it can be a principal, teacher, licensed athletic trainer, coach, paraprofessional, or licensed PT or OT who's employed by the district, or can be multiple of these individuals. It doesn't have to be only one other qualified school employee. In order to administer an opioid antagonist to students, the school nurse or the qualified school employee has to do so in accordance with Board of Education's policies and procedures regarding the administration of medication. So in other words, your Board of Education has to revise their policies to address these requirements. And in doing so, that it should be done in consultation with the school's medical advisor and kind of supervisory nursing health staff. So the new provisions allow the school nurse or the qualified school employee to distribute and administer opioid antagonists only after completing a training. So everybody who's going to do this on school grounds now has to undergo training. And that training must either be offered by the State Department of Ed together with DCP and DPH, or pursuant to an agreement with a prescribing practitioner or pharmacist. And my understanding is that prescribing practitioners and pharmacists regularly do this for police departments and other types of agencies. So they would probably easily be able to do it for Board of Education as well. In addition, the law talks about what that agreement has to cover and likely what the training that's provided by the SDE, DCP, and DPH covers. It has to address storage, handling, labeling, recalls, and record keeping of the opioid antagonist. And the agreement has to provide that the prescribing practitioner or pharmacist will train the individuals who will distribute or administer the opioid antagonists under the agreement. And you can enter these agreements as of July 1st, so currently. So there is another exception in the law for emergency administration of medication, and that's for epinephrine. So similar to the statutory provisions regarding the emergency administration of epinephrine, this new law prohibits schools from administering opioid antagonists to a student if the student's parent or guardian has submitted a request in writing that it shall not be administered to their child. The request can be submitted to the school nurse or the school medical advisor, if any. This new statute also requires that DCP, Department of Consumer Protection, in collaboration with the State Department of Ed, has to provide information to boards of education regarding where boards of education can acquire opioid antagonists, including the name and contact information of any manufacturers that provide medication at no cost to school districts. And by October of this year, the State Department of Ed has to develop guidelines regarding storing and administering opioid antagonists in schools. Our guess is they're probably going to mirror what some of the guidelines are for epinephrine, the emergency and administration of medication of epinephrine, but we'll see. We'll see what comes out October 1. Okay, so scenario to break it up a little bit. Your district is keenly aware that opioid use is a problem at the high school and perhaps the middle school. Nothing's more important to you than student safety and well-being. You decide that your school will have opioid antagonists like Narcan in case there's ever an overdose at school. Right before one of the first soccer practices of the year, a student athlete appears to suffer an overdose. The trainer jumps into action, grabs the appropriate medication, and administers the opioid antagonist. So the question is, are there any issues with this approach? And what if it was an assistant coach suffering the overdose? So the issues with this approach now is that you have to have a board policy and procedures in place that meet all of the statutory requirements that we just went through. And that trainer has to be one of the qualified school employees who is authorized to administer the medication in an emergency situation to students. They have to have been trained and have met all the other statutory requirements. So if all that's been met, then we're good. The question has often come up, even before this law, districts that have had Narcan kind of on hand to administer have asked, well, can we administer it to an employee? What if it's an employee, or what if it's a parent? What if it's not a student? So the administration of medication statute really specifically addresses what has to happen when you're going to administer this medication to a student. Administration of this medication to kind of others outside of that group, of that student group, right? You probably wouldn't need written authorization from a parent of an employee anyway. It's kind of a different calculus here. And so I think in that case, kind of Good Samaritan laws would apply. It's something you can talk to with the people who do the training, but my understanding is that there are really no negative side effects of administering the medication. So that's something that you as a district would have to make a decision about as to whether this would be available to use for employees or parents who might be in an emergency situation. Okay, some more things about student health. There's going to be a lot of new surveys that the school districts are going to have to fill out. And one thing I should say, we did not include slides in this presentation regarding corresponding grants that are available for school districts this year, but I think all of this information is going to be used by the State Department of Education in determining grants, or at least to inform grants and kind of where the need is throughout the state in terms of mental health services. I will share that link with Alicia, and then she can share it with you with a full summary of our legislative summary, and all the information about different grants that are available is indicated and described in that document, so you can refer to that. But for now, we'll just talk about some of the surveys that are required to be developed and then distributed and then completed by boards of education. So by July 1st of next year, boards of education are going to have to complete a new survey that the State Department of Education is required to develop regarding the number of each of these types of individuals that are employed by the Board of Education: the school social workers, psychologists, counselors, nurses, and licensed marriage and family therapists. That survey, just as a heads up, is also going to include the number of each of those types of 5 professionals that are assigned to each school, whether they're assigned to one school only or to multiple schools, whether they provide services to only one Board of Education or throughout an entire geographic area that might be shared among more than one Board of Education, and an estimate of the number of students receiving direct services from each type of professional. The State Department of Ed is then directed to kind of calculate ratios, and what these surveys are aimed to do is to determine, what is the extent of mental health services that are being provided to students throughout the state, and where there might be additional need. So next year, you can see those surveys coming. You'll have to fill them out. A separate law directs the State Department of Education to develop a survey concerning school mental health specialists. There's a lot of overlap with the first law we talked about, but it's going to be another survey, again, addressing school social workers, psychologists, in addition, and school counselors and LFMFTs. But in addition to those professionals, you'll also have to record data about trauma specialists, behavior technicians, BCBAs, and licensed professional counselors. Like that first survey we talked about, you're going to have to record the total number of school mental health specialists in the school district, how many are assigned to each school, and an estimate of the annual number of students who receive direct services from each of those types of individuals in the prior 5-year period. And then there's going to be one more survey, a little bit more paperwork. The new law requires the Department of Public Health, beginning this year and then biennially, to administer a Connecticut school health survey to high school students if DPH receives funding for the survey from the Centers for Disease Control and Prevention. So we'll see if that happens. Department of Public Health will provide guidelines to boards of education regarding how to administer the survey. And those high schools are going to be randomly selected by the CDC. So this may or may not apply to your district. And then by January 1st of next year, in consultation with DPH, the State Department of Ed has to develop a uniform parental notification policy and form for boards of education to use in administering the survey. So if you're selected to administer the survey, there'll be more guidance and also a parental notification policy and form for administering it. And parents will have the opportunity to exclude their children from participating if they want to, and the survey it has to be anonymous. All right, we're good. We're doing well. We're almost there. So that was the major overview of all of the changes from this past legislative session in 2022. As I mentioned, I will send Alicia the link so she can send it out with this presentation so that you have a full kind of narrative summary of all of these changes and a few more in case for inquiring minds that want to know. And like I said, those materials also have summaries of the grants that are available starting this year. But I wanted to kind of, as part of this presentation, just include a few reminders of new policies that are required to be in place starting this July 1. These were laws that were passed in the 2021 legislative session, but they go into, they're required to be implemented this year. So the first is that boards of education are required to have a policy concerning the eligibility criteria for enrollment in an advanced course or program. So again, like I said, not later than July 1st, boards of education have to have this policy in place. There's also been, since the law was passed in this past year, there's significant State Department of Education guidance regarding what those eligibility criteria can and should entail. Boards of education are also required to have a new challenging curriculum policy, which kind of goes hand in hand with that advanced course or program policy. That challenging curriculum policy has to include criteria for the identification of students in grades 8 and 9 who can be eligible to take or enroll in those advanced courses or programs. It has to have identification of kids in grades 8 and 9. It can include identification for kids in other grades if you so choose. And it also includes, the policy has to include a provision requiring the creation of an academic plan. So this kind of builds on the requirement that every student grade 6 and up, I believe, has to have a student success plan. Now students who have been identified as eligible for an advanced course or program also have to have an academic plan. In addition to that, kind of, and I should say the main kind of thrust behind those two policies and the next one that I'm going to talk about are making access to these higher level courses more equitable. And, you know, it's kind of through an equity lens to ensure all kids have, you know, there's just not strict one criteria for qualifying for some of these advanced opportunities. So like the advanced course or program requirement and the challenging curriculum policy, boards of ed also need to have a policy for the equitable identification of gifted and talented students by this year. And the policy has to require the use of multiple methods of identification of gifted and talented students. And again, State Department of Education in the past year has come out with, I think it's like 8 or 9 page guidance regarding those criteria and different ways you can identify kids for gifted and talented programs. Interestingly, under state law, there still has not been a change regarding whether you need to provide gifted and talented services to the kids, but you do need to identify them. And if their needs can be met through differentiation within the regular curriculum, there doesn't need to be a program created for them, but there does need to be a process for identifying kids who might be gifted or talented. And then finally, there's a new requirement that boards of education have to adopt for this year, a policy to improve completion rates of the free application for federal student aid for students enrolled in grade 12 or an adult education program maintained by the board. This doesn't mean that you need to sit down with every kid and fill out the FAFSA with them. We've gotten that question. It just means you need to have a policy for, advertising the importance of the FAFSA, or where to get the FAFSA, or why you might want to fill it out, and kind of resources available for students who are interested in that and trying to improve those completion rates. All that being said, you don't have to sit down with each student and fill it out. There is a grant position that I mentioned earlier that if you do receive that grant, that individual is actually statutorily required to assist students with the FAFSA applications, but only for that grant position. Generally speaking, boards of education just need to have a policy to improve the completion rates in the district. So I think that is it. We got through it. I wanted to stay within our 2-hour time. I don't know if we have any further questions, but I'm happy to answer anything else.
We do, Dori. There's a few that came in that are related to past topics.
Okay.
So going back to recess, if a middle school has a grade 5 in it, do they fall under the recess requirement? Or because it's a middle school, do they not?
So it's for as memory serves, the requirement is for elementary school kids, not elementary schools. But I think you're going to need to fall under that statutory requirement. But I'm going to look into further just to see if there's any clarification about, because you're right, we used to all have K-6 schools, right? Like when I was growing up, it was all K-6. Now there's different configurations of schools. So I think it's for children in elementary school. So that's when you're going to have to look at that definition of what elementary school is for kids.
Okay. And then your scenario spoke to a child who stays in to work and loses their recess because they frequently take up the whole thing. What if they're in for 10 minutes and the recess block is 30?
Yeah. Well, if the recess block is 30, so this is a little bit of a gray area because you have to allow it for at least 20 minutes. But the general gist of the whole law is not preventing or restricting time that's devoted for physical exercise. So I know that some other districts and to be honest, it's unclear in the law whether you can take a 30-minute recess and make it into 20 for the academic related reasons. But the whole gist of the law is to get kids outside and play. And so if there's another way to have them complete their work, I think that would be the best course.
Okay. And then can we jump to teacher?
I think we could have a whole thing on recess. We're going to have a follow-up.
We could.
Wait, maybe we'll meet at a state park or something and do it outside.
On May 26th.
On May 26th. Oh, you're paying attention.
For early release days for teachers or for any variation of a non-full day,
yep.
Are teachers still required to have that 30-minute duty-free lunch? If it's a half day, if it's an early release day, if it's a inclement weather half day?
So we have been asked this question and it's not specified in the law, but our best guess is that if it's in their regular work day, so if they're required to work, they have to have 30 minutes within their work day, but it doesn't necessarily need to be within the kids' school day.
Thank you. Those are all the questions we have.
Thank you, Dori. Thank you so much. This was very informative as usual and timely. Of course. So thank you for this wonderful presentation and giving us, a lot to think about, not only for now, but also for the future. And certainly for CAS to think about how we can support our schools and our school leaders in implementing many of these new legislative mandates. Again, I want to thank CAS's sponsors, so Horace Mann and Chet. This recorded presentation, the slides, and the legislative summary that Dori referred to, we will make sure those are emailed out to all registrants, and they'll be available to you in the next few days and on our website. And then I'd also like to just take a minute to share some upcoming workshops and seminars that CAS will be hosting. We have scheduled administrator supervision and evaluation training for anybody who supervises somebody with an 092 cert. We also are hosting an Aspiring Leaders Academy as an effort to retain and grow our teacher leaders. We have a Purposeful Play workshop coming up as well. And you can find many of these things and other important updates in our weekly CAS news blast, including Dori's colleague, Tom Mooney's weekly mailbag, which always keeps us on our toes. So thank you again to Dori. Thank you, Tiffany. And we wish you all a wonderful rest of the day. Take good care.